Hello, and welcome to the Columbus Metropolitan Club. I'm Deb Hackathorn. I'm a member of CMC's Board of Trustees. I'm also a government affairs representative with Frost Brown Todd. Over the past several weeks, racism and systemic bias has been acknowledged as never before. In our longstanding tradition, CMC is developing forums that provide community space to explore these issues. In our continuing series, Racism, Where Do We Go From Here? We are live streamed thanks to our live stream partners, WOSU Public Media, the Columbus Dispatch, WBNS 10 TV, and PNC. We'd also like to thank those of you who purchased a virtual seat for today's forum. We're very grateful for this support, and we're able to continue our live streaming services in large part because of you. Thank you. Welcome to today's forum on justice reform. Bias, lack of diversity, inequality of access and representation are all issues that the nation is wrestling with today, and America's system of justice is no exception. Calls for change echo in the halls of justice. And what those challenges or changes might entail is our topic for today. First, I want to mention that unfortunately, Judge Marbley had a conflict and was unable to come today. However, we have a wonderful panel of experts and a substitute for Judge Marbley. So please welcome Judge of the 10th District Court of Appeals, Laurel Beatty Blunt. Partner and Director of Litigation, Training, and Pro Bono Activities with Ice Miller of Columbus, Diane Menashe. And our host for today, the Managing Director at Draper Richards Kaplan Foundation and the former presidentially appointed U.S. District Attorney of the Southern District of Ohio, Carter Stewart. Thank you all for being here. Carter, the stage is yours.
Great. Thank you very much. It is an honor to facilitate this conversation. I do want to make one slight correction. I was not the U.S. District Attorney. I was the U.S. Attorney. No, that's fine. It happened all the time. But I also want to thank you, Deb, and Jane Scott and Andy and the leadership of CMC for having this conversation in the first place. Conversations about race are never easy. Conversations about race are usually uncomfortable. But if we don't have them, nothing's going to change. So I just really appreciate the leadership that CMC is showing by having these conversations. Today's conversation is going to be rather unique. Usually, when we talk about bias and systemic racism in the justice system, the focus is on prosecutors and the decisions that prosecutors make in terms of what charges to bring, what sentences to ask for. But today, you are actually going to hear from a judge and someone who represents the defense bar on their perspectives of bias and systemic racism in the justice system. So as a former prosecutor, it's nice to turn the heat on other folks. And I'd like to start with you, Judge Beatty. I'd like to start with defining the problem. And if you could please share with the audience what you see as the dangers of bias and systemic racism among judges, and what you have seen yourself as from your position.
I think in looking at bias and racism amongst judges, it is, and actually anyone involved in the justice system, it is very important that you not look at the issue piecemeal. You can't just look at the issue of things that happen with the police. You can't look at just the issues that happen with sentencing. You have to look at everything that happens in between. When a judge is presiding over a criminal case, they are making decisions about bond, they're making decisions about what evidence comes in, they're making decisions about who can testify and about what, they're making decisions about what information can be exchanged. They're also making decisions about people getting screened or entering into diversion programs where if someone were to satisfy certain conditions, their case would be dismissed. They're also making decisions about accommodating people with special circumstances. They're making decisions about jurors being dismissed. And then finally, they're also making decisions about sentencing. And so we have to look at the entire process as a whole when we're examining this issue.
And have you seen instances of that you would consider racial in nature or biased in nature among judges that you've?
Yes. Starting with, honestly, my first chambermate, I later found, I noticed it was me. I had a black woman who was my bailiff and a white male that was my staff attorney. And I noticed that my chambermate would only talk to the white male. He would never talk to me. And then I later found out that he would call me a nappy-headed girl to anyone that would listen. And another time when I was campaigning a 4th of July parade, me and my volunteers had tennis balls thrown at us, called niggers, show us a real judge. So I have experienced that personally as a judge. And here's the thing that is unique to black judges, is that we have to experience those things and then turn around and be fair and impartial to all people, which is just something that other judges don't have to do.
Yeah. Wow. Diane, same difficult question for you in terms of what you've seen among the defense bar as evidence of bias or systemic racism.
So as we were talking and I was thinking this through, I think the heart of my answer to this question is the empathy piece, right? Is really being able to empathize with others. And why I lead with that statement in my answer is because I think that's where defense attorneys are failing. There is a misconception that all clients should be treated the same. And when we do so, inevitably bias creeps in. And instead, we should be approaching every individual on a separate basis and really coming to understand where they are and how they got there. And that's the empathy piece that I think is so critical. Because what we as defense attorneys are missing when we're not using our empathy and we're just being robotic in our work is that when we're advocating for our clients, right, we're really just, we're missing so much. So for instance, if I have a black client that has a particularly long criminal record, I have seen so many in my bar essentially discount that client, right? At the sentencing hearing, they're not truly being an advocate. They're not asking for anything less than the prosecutor wants. But instead, why don't we contextualize that prior criminal record? Why don't we investigate? Why don't we find out, was that person involved in children's services? What was the family history? Were they a single parent home? Did they suffer from poverty? What are the facts and circumstances that contextualize that criminal record? Because I know, certainly from doing my felony work, in particular my death penalty work, is that when you are able to contextualize, what you inevitably do is you humanize. And when you can humanize, right, each case, well, then everyone involved not only feels, well, they feel heard, which is so important for our clients, but inevitably the result is more equitable. It just is. So I think that's the greatest fault of the defense bar, is just approaching every client the same, and by in so doing, we're doing a disservice to the clients of color.
Yeah. A lot of folks have talked about increasing the diversity of the bar, either the judiciary or the defense bar, or prosecutors for that matter, as being a key element to changing the system. How important is it, from your perspectives, for that diversity to match the communities that are represented, or if not matched, at least have the judges or lawyers know the community or be familiar with the community from which the clients are coming? Judge Beatty?
I think that is extremely important because even if you don't increase diversity on the bench, judges cannot afford to live in a bubble. Because particularly in the criminal context, we're dealing with people's liberty, and sometimes dealing with people's liberties for long years. And so we have to understand, even if you have a case where there is a presumption of probation, if you don't understand the issues in your community, if you don't understand how race, class, poverty, sexual orientation, having insurance affect that person, you might not even get the terms of probation correct. So it is important that there be not only a diverse judiciary, but also a judiciary that understands how people get to their courtrooms.
For you, Diane, the diversity question as it relates to the defense bar.
Huge, I think, for myriad reasons. I would say first and foremost, because I do put the clients first, is just to, I mean, when your life is on the line, there is something to being represented by someone that looks like you. And I'm cognizant of that every time that I represent someone that's black or of color, that here I am, you know, a white woman walking into their room, and in a capital case, let's say, their life is literally on the line. And, you know, I'm going to spend 80 to 200 hours with that individual in a room alone. And here's the truth, they've probably never spent that much time with a white person alone before. And so I think first of all, with respect to the makeup of the bar, it's very important for the clients to feel represented. I also think it would benefit the bar itself, because this goes to that empathy piece. We need to be exposed more to diversity and inclusion and equity, we being the bar. And I just don't think that's possible if we continue to live in the white bubble that we are generally living in. And I'll add to this, Carter, is that, you know, there's also a drastic underrepresentation of women in the defense bar. And so we've got this two-layered problem. First is the absence of women, and then also the absence of people of color, and then women of color in particular. So I think it's critical from the client perspective, and also it would make us all better defense attorneys to have a more diverse bar, for sure.
If I could add to that, Carter, I really question how a defense attorney could effectively do their job without understanding some of those issues. And here's why. Because particularly when it comes to sentencing, the defense attorney's job is to argue for a certain sentence. Or if they have a certain understanding of their client, they can argue for programming when appropriate. Or they can, if they know that a judge has certain opinions about black people and they have a black defendant, they can try to navigate around that so the person does not get such a harsh sentence just based on their race. And then finally, a defense attorney's job is also to present mitigating factors. And so if you don't understand those things about your client, you can't present mitigating factors either.
So lack of diversity, lack of connection to the community that many clients come from, how do we get over that? How do we account for that? How do we actually make a difference to changing the environment, reducing bias in these systems? And this can go beyond defense bar, beyond judiciary, but what would you do if you could wave a magic wand and change the justice system to make it more fair? Diane, I'll start with you.
There's so many, this is like Pandora's box, right? Like, this is my dream question. But I will, for purposes of today, keep it focused to defense attorneys. I mean, first of all, there have to be proactive efforts to make the bar more diverse and inclusive. This is thinking that it will happen organically. Well, we should know by now that that's just not true, right? That organically, we will just not become a more diverse and inclusive group of people. So there need to be proactive efforts in terms of identifying particularly young litigators to join that are diverse. Also, I think there just has to be a more cohesive environment between the defense bar to enable mentoring. We certainly do have the system in the federal courts with the CJ panel. There's a mentoring relationship of more senior litigators with newer litigators. We don't have that at the state court system. And I think that's one of the barriers of entry, is that younger lawyers that are now more diverse don't know how to get in, right? And when they are in, they don't feel included. It's just like what we talk about is, well, you can ask people of color to the room and give them a seat, but do they really feel like they're welcomed in that room? And the defense bar is at fault for that. And it's not an easy solution. I think it would take a great number of us to make the time and effort and to be mentors, which is a non-paying gig, right? But I would submit that the reward that could come from really great mentoring of younger diverse attorneys would be exponentially great, not just for the bar, but for the clients.
And in our prior conversation.
And the judges, sorry.
Yeah, that's fine.
And the judges, yeah.
In our prior conversations, Diane, you also mentioned the power of data, just to expose the issues as they exist. Could you talk a little bit about how data plays into pushing for reform as well?
Yeah, so the judge spoke to part of our job as lawyers, certainly a huge part of it is presenting mitigating factors to the judges at sentencing, explaining to the judge, while yes, on paper, this crime perhaps seems horrific, or yes, this is a very high-level felony offense, the mitigation is not an excuse as to why the client has committed that offense. It's an explanation as to why the client is where they are and how that might have come to pass. So what's critical, I found, in that mitigation piece is understanding sentencing disparities when it comes to race. And, you know, Carter or Laurel could ask me, Diane, do you feel like there's systemic, you know, bias and racism with respect to the judges, let's say, in Franklin County? And I would say yes. They would say to me, do you feel like there are charging decisions at the prosecutor's office that are based on race? I would say yes. Are plea offers, better plea offers offered to those that are white than blacks? Again, I would say yes. But here's the thing about data, is that it's not Diane Menashe saying based on my 22 years of experience, or Laurel saying based on her experience, or Carter, or Mary, or so on and so forth. The data, right, is objective. And what we don't have in the criminal justice system is data collection and analysis. So what happens is that there's no measure to hold judges and prosecutors accountable for either their sentences or their charging decisions. So quickly, Carter, if I could, I had an involuntary manslaughter case in Franklin County about 4 or 5 years ago. There is a provision of the involuntary manslaughter statute that if you provide heroin in any way, even if you're a friend, to someone and that person uses the heroin and dies, you could be charged with involuntary manslaughter. And I had a case where the prosecutors were asking for a period of incarceration that I thought was, for lack of a better word, insane. And prosecutors that I've dealt with all of my career, so I understand where they're coming from and they understand where I'm coming from. So we went back and forth, and I couldn't help but think my client is the reason for this high-level number, who had no prior criminal record, by the way, and quite a bit of mitigation. And this was a friend-to-friend transaction. And so what I did is I spent, now that I've calculated it, 39.4 hours pulling the data for every involuntary manslaughter case in the history of Franklin County that was charged and pled out under that statute. And I crunched the data and put it into a spreadsheet and attached it to my sentencing memorandum. And instead of the 13 years that the prosecutor was asking for, guess what the average number that a white person was not only getting as a jointly recommended sentence, but was getting from the judge? It was 4. So guess what happened? I argued for 4. And the judge, Judge Young, gave 4 years and 11 months. So that's the power of data, right? Because it's not what Diane's saying, it's not what someone else is saying or my perception, me arguing that I thought that their recommendation was racially biased. That's not getting me to the number I want, and that's not getting my client to the number that she deserved. But the data is such a critical piece, and sorry to make such a long-winded answer about this, but I'm pretty passionate about this data issue. We need data collection, a statewide data collection with respect to sentencing in Franklin County and Ohio overall, because it's a tool defense attorneys need to use, and I believe that we can't get to really addressing racial justice until we peel back the layers and we have more transparency with how is race really impacting our judicial system.
Very, very quick follow-up to that, Diane. Did Judge Young mention that the data that you presented had a big impact on the decision?
He did.
Okay.
He did. In fact, it was like I can't ignore the data. You know, and Judge Young is someone I tried a death penalty case with years ago, so we know each other well. This wasn't a Diane Menashe, brilliant argument. I felt like it was brilliant because I had the idea. But what's really critical about this, and I can't fault my defense bar for this, who has 39 hours to give to a case? And when I pulled, Justice Donnelly and I were recently talking about this, and he asked me how much time I spent on that effort, and I pulled my time log, and I have to say, I was like, wow, yeah, like I'm busy, so but we don't have that kind of time. And that's why the data needs to be there, so we can pull it as a resource and have it in our pocket. And actually, I dare say, this isn't a resource for defense attorneys, also for judges.
Yes.
Judges need this, because judges need to understand, especially as we're electing new judges, what does the history look like? Do I want to be on the side of history or on the other side of history as we move forward as a city and as a state and as a country?
And I agree with you, Diane. I was happy to hear that the Supreme Court is pushing an initiative about a statewide sentencing database. And to your point, the other disparity that would help with is, for example, if you're in, say, someplace like Reynoldsburg, and a crime is committed in Franklin County, part of Reynoldsburg, versus the Licking County part of Reynoldsburg, those two sentences can be completely different. And it all depends on what side of the street you were on. And so a statewide sentencing database would help that. In order to change the system, to your question, Carter, I would involve everyone, because I think that we all need to realize that everyone is involved in this. When you talk about, for example, the state system, you have the legislature that passes laws. You, as judges, we don't make those laws, we apply those laws. And then you have the public. And the public is important because the public needs to understand and be interested in certain races, because the public votes on the mayor that deals with police. The public votes on the prosecutor in Ohio, the county prosecutor that makes all types of charging decisions and plea offers and things like that. The public also elects judges. And if you look at voting information, the drop-off for down-ticket races is pretty bad. The other thing is that the public also needs to understand the importance of answering their jury summons. Because a lot of times you hear people that were upset, oh, this black defendant was convicted by an all-white jury. But did you answer your jury summons the last time you got one? Or did you call someone like me trying to find a way out of it? But I don't think a lot of people actually realize that in a jury trial, it is the jury that is deciding guilty or not guilty. Sure, the judge makes the decision regarding sentencing and motions and evidence and things like that, but it's the jury that decides whether someone is guilty or not. And so I cannot emphasize to you all enough the importance of answering jury summons and also voting and educating yourself. You know, while I would love to think that I won my first race with 68% of the vote because I'm very smart and fair, but someone told me that my yard sign was in their neighbor's yard and their neighbor always keeps their grass cut, so they voted for me. But we have to have an educated and interested electorate for all the players in the justice system.
Just want to add one comment on the data piece. It's actually, in my experience, in law enforcement's best interest to pursue data as well. In the same way that it can show some biases, it can also show lack of biases. And there are studies done in the federal system, and I can't remember the type of cases that they focused on, but they actually showed that there wasn't a correlation based on race, and obviously sometimes there are as well. But it's in everybody's interest to find and get the right kind of data.
I couldn't agree more, by the way.
Yeah.
And it's because there are parts of our system that are working.
Yeah.
In the federal system, there are the sentencing guidelines, which certainly do seem to eliminate some bias that isn't that the state judges don't have. But I completely agree. I think data is a win for all, and it just is how to get to equity. That's
Right.
It's just how to do it, which will benefit all of us.
Yeah. So the issues that we've talked about today we've been talking about for years. We talk about inclusion. Data is newer, but knowing the community, it's been part of the community discussion about race for years in criminal justice and education and all kinds of areas. Do you have hope that there's something different about today, that the recommendations that you've talked about can actually come to pass in Ohio or elsewhere or locally? Is there hope for achieving the goals that we're talking about here in the justice system?
Honestly, Carter, as a Black female judge, I have to have hope. Because if I don't have hope, I'm a part of a system that is perpetuating things that have historically hurt my people. I have to have hope. But I have been very encouraged by discussions like this, because I think that a lot of people are becoming more curious about how racism affects our society. And I also think that Black people are more comfortable. They're being given more platforms to talk about. Because when I think about these things, Carter, and I wonder if you would agree with me, but when you look back, navigating racism is just a part of child rearing in a Black family. And a lot of people did not realize that. A lot of people did not realize how racism affects Black people's everyday life. And I've also heard from a lot of judges that are realizing, no, they're not racist, they're not, a part of the KKK, but there were some things that they were missing that probably affected some of their decisions, and had they been paying attention to a few more things, they may have decided some things differently. And so I'm encouraged by discussions like this. I'm encouraged by a lot of the young people that are speaking out, and hope that it will create change.
Diane?
I've certainly heard this expression, and I've adopted it as my own, but we are in a time of a racial awakening, and that is just the truth. And I think it is magnificent and brilliant, and we should let the light shine and turn it up. That's how I feel about it. And I am so optimistic. I've always been despite the darkness of my work, I've actually always been a glass half full person, and I'm really glass full at this point. Because we are having conversations like this. I think that people are leaning into learning, which is what's necessary for change. And I also think that it's causing even those of us that have been walking the talk. And I'm going to put myself, in that bucket if I can. I feel like I've been representing individuals for 22 years in the best way that I know possible. And I can tell you that certainly my moral compass has pushed me in a direction that I am an advocate working without bias. That said, it's even forcing me to self-reflect. So for instance, I recently moved from private practice, or from having my own firm, to Ice Miller. And, I look back and I think I should have done more pro bono work. I should have represented more people of color at no cost. And yes, I hear what they're thinking. Well, it's not possible for solo practitioners to have that freedom of choice. I actually disagree. I disagree because I believe that to get to equity, we, white people, need to make a financial sacrifice. And if we're not making a financial sacrifice to help equalize things, then we're just not going to get to a playing field that is actually equal. And so I think this time is making people, hopefully like me, do a deeper dive of what more can I do? And you know what, I've determined there's a whole ton more I can do. For instance, again, I'm fortunate to work at Ice Miller and they're letting me do this work, but I used to charge for judicial releases. The truth is that our prison system is overwhelmingly Black. It has got to change. And I used to charge individuals, of thousands of dollars to file for a judicial release application. And here's the truth, is I represented very few Black individuals on a private basis for those applications. I have now decided that I do those at no cost for people of color. When the crisis hit in our systems, our prison system at Pickaway, we had 2,000 positives in a prison that was 1,800 capacity. We set up a program called the Pickaway Prison Release Program, where we represented people of color at no cost for judicial release purposes. So it's a time when we have to think more about what we can do, even those of us that think we were doing it great. So I'm super optimistic. And there's so much work to be done, but I feel like the audience is just so big, and there's so much passion and heart. We're gonna do it.
Could I add something, Carter? I think that when we talk about the judiciary and racism, we automatically go to criminal law and we automatically go to sentencing. And like the point that I made before, that there's a lot more to that before you get to sentencing. But we also need to talk about if a judge has any type of bias, consciously or unconsciously, it can affect their civil docket too. So for example, when I was on Court of Common Pleas, General Division for 10 years, I had felony criminal cases, but I also had civil cases over $15,000, all the way up to cases worth millions and millions and millions of dollars. So a lot of those civil cases, you are dealing with a business's livelihood. And so if a judge has any type of bias, it could affect the outcomes in a civil case also. Because, for example, I had a friend that really felt that the judge did not approve of a black female lawyer being in his courtroom. And so, being an ethical attorney, she had to go back to her client and say, I think my race and my gender are going to affect your case. So that not only did she have to have an awkward conversation, but that also messed with her business. Also, if a lawyer is black or if a client is black, you could be looking at the evidence through a certain lens that you should not. And so that is not only going to come in on your criminal docket, it's going to come in on your civil docket too. The other thing I think that we have to look at too is with all of these talks, we have to decide what we want to do as a society. Because if we want to go straight law and order, then we have to put money into prisons. A lot of people argue that that takes money away from schools. So you put money into prisons, and then you have to put money into other social programs because it is so difficult to find a job, to find housing, things like that with a felony on your record. Or society can decide that perhaps we do believe in redemption. And if that is the road that we're going to take, we're going to put the money into substance abuse programs. We're going to put the money into programs that help people that have mental illness. We are going to put money into programs that address cognitive thinking errors. So for example, what I mean by that is, I remember when I was a judge, I had an assault case, a felonious assault case. And this guy honestly had really beaten someone up really bad over some chicken nuggets. But when I thought about it, I said to myself, I looked at his pre-sentence investigation report that provides a ton of information. And I realized I had the fortune of playing t-ball when I was in the 3rd grade. And I learned if you get mad, you can't throw the bat down, and you certainly can't hit somebody with the bat. But when I looked at this person's pre-sentence investigation report, that is what he learned. That is how he learned to resolve conflict. And so you have to put money into programs to change that type of thinking if you're going to go the route of redemption.
So we have 1 minute warning that we're going to accept questions from the audience and also from our live stream audience after this quick question that is probably too difficult to answer quickly, but I'll ask it anyway. The people in this room are here because they care about this issue. The folks who are live streaming are watching this because they care about this issue. How do we reach the folks who are not in this room and who are not live streaming with the messages that you have just given?
We use the people in this room and the people that are watching as ambassadors. Tell them, tell all your friends, tell all your family. Say it louder for the people in the back. Spread the word. Vote. Answer your jury summons.
Yeah, I think conversation is key.
Yeah.
And that's another responsibility that each of us that do care need to carry. We need to keep having the conversations, even in an audience where we feel like this might not be my audience. And you know, I go to some barbecues and parties like that. But it's having the conversation, and I go back to that. It's leaning into learning. And I think if you lead with that hey, listen, I'm trying my best too. I'm trying to lead with learning too. That it opens up a more really a more safe atmosphere, right, for an honest conversation.
Great, thank you. It's now time for questions. Jane, I'll turn it over to you, and would just ask folks to ask questions and not give editorial comments. But Jane?
I'll start with a question. I'm Carol Looper. Is there data that reveals how the racial makeup of a jury involves how the verdict comes out on the race of the defendant?
I'll take that one. We don't have any data in Ohio with respect to that issue, whether the race of the jury has any impact on the verdict, dependent on the race of the client. We don't have any systemic or with respect to what sentences are handed down or charging decisions. We have nothing. What we do have is there is a Hamilton County study that was done on the impact of race in the administration of the death penalty. And that was done in combination with the Federal Public Defender's Office and Michigan State Law School professors. And that study overwhelmingly showed that if you were black and the victim was white, you were more than 3 times more likely to be charged with the death penalty as well as convicted of the death penalty. And I'm proud to say that we're at Ice Miller now going to do that same study in Cuyahoga County with the Michigan State Law School professors because, as you've sensed, I'm real passionate about this data collection. But Carol, I'm going to add that to the list of things we need to gather data on, for sure. But there needs to be financial resources put towards that data collection. And as Laurel mentioned, 2 of our Supreme Court judges are really, really advocates of this work. And I'm hopeful that their push that's now supported by all bar associations in the state will come to fruition and funding will be given and a database will start to be collected.
Mrs. Looper, I'd like to address your question also. You know, we don't have that data in Ohio. The best you're going to do are probably academic studies that are very broad. But there are studies out there that talk about, for example, the rate that black jurors are challenged, you know, meaning taken off the jury, and also the rate that judges allow prosecutors to give supposedly neutral reasons for striking a black juror that, you know, are sometimes questionable. For example, one study I was reading was talking about a jury pool that started out 50% black, ended up with two black jurors. And one man was stricken because he was singing or whistling "The Sun Will Come Out Tomorrow" as he was leaving the courtroom. So we don't have that data in Ohio.
And if I can, I just want to go back to your original question and integrate your question, Carol, about where the defense bar is failing with respect to racial bias. Defense attorneys that are picking jurors that are white are not considering race as much as they should be. They are picking jurors, I believe, more on jurors they like or they think might be politically aligned to their particularly facts and circumstances. And what they're not thinking about is what their client sees and feels when they're sitting in a chair with their life in the line, looking at 12 people that are all white when they are black. And I think that's another failing of the defense bar. And that could be helped through mentoring too, is really with understanding that picking a jury is it's not Diane, what the jury Diane Menashe wants, right? It's the best jury for Quentin Smith or for who my client is. So I just wanted to add that.
Well, we have quite a number of questions, so I'll try to move forward quickly. Carly Bose, some doctors are prescribing affordable housing to remedy health conditions. Can courts use a similar approach to sentence defendants to a stable environment that deters recidivism?
I think they can, but they have to be there to sentence them too. It's very interesting when I go to judicial conferences. The disparities between counties in Ohio is astonishing. We are very fortunate in Franklin County. We have the community-based corrections facility. We have all that Alvis does. We have Maryhaven. We have places in Franklin County where people can go. There are counties where pretty much the choice is the jail, the prison, or home. And there's nothing in between. So I do think that that could work, but it has to be there for us to send them to.
And I want to dovetail on that. If people say, well, what about electronic monitoring? I first say that the cost of electronic monitoring is put on the client to pay.
Yeah.
And that's our first problem, is that we then talk about racial bias, right? We have individuals that literally can't afford the daily monitoring fee, and if you can't afford it, then you're not eligible for that program. So I think that idea is certainly a wonderful one. I would dovetail on, then we need more facilities to use in that way. But also, we need to create change in the systems that exist. Monitoring should not be a cost forced to be paid by the individual that's monitoring. This is our responsibility as a state and as a county and as a city. Because I know Carter knows this, but the federal government, the DOJ, has done plenty of studies on the fact that someone spends one night in jail, just one night, and their risk of recidivism is exponentially increased. We have to keep people out of jails and prisons if we can. We have to give them a chance at programming. And this circles back to that empathy piece, understanding the client.
Oh, sir, yes.
Yes, my name's Otto Beatty, and I promise not to editorialize. We'll be here all week, but I was so pleased to hear you ask a question, or somebody asked a question, or bring up the issue about data. About 15 years ago, there was a judges meeting, and I remember it like it was yesterday. There was a judges meeting, and the judges in that meeting asked themselves, do we want to have data on what judges do what? When that meeting was over, it was a resounding no. And I haven't heard anything since then about judges being willing to give the data or even want the data. So my question is, what agency, administrative agency, state government, or who would have the authority to require that data from judges? Because I still am a little concerned about if we have to depend upon them to voluntarily give that data, you're not going to get it. Now, defense attorneys, Diane, can tell you, they've got the data from experience. They can tell you who's going to jail, who's not going to jail, how long they're going to jail, and they can prognosticate about what's going to happen. And a lot of that depends on what judge you draw. You draw Judge A, you're going to jail. You draw Judge B, and it's the luck of the draw. You draw Judge B, you might have a chance of probation. So back to my question is, what agency, be it administrative or legislative or whatever, could require us to get that data? Now, I'm not saying that it has to be rigid like they tried to do with the federal system, but I do think that getting data on judges puts pressure on them, even from an election standpoint, to be fair and to be reasonable. So that's my question. Thank you. No editorial.
I believe the Supreme Court itself is proposing to collect that data.
Yes.
And to your point, immediately when you said it, I was thinking, yeah, they don't want that data out there because we have to run for election on the state court level. And some information might get out there that could hurt or help your election. And so some would think that it's best not to have it at all for that reason. I disagree with that, but I would anticipate that certain judges would argue that.
And to answer your question about how would the data be collected that the Supreme Court two of the justices are proposing, certainly not relying on the trial court judges to supply the data. They would collect the data from clerk of courts based on judgment entries, and they would really be pulling dockets, as I understand the data collection. So it wouldn't be dependent on a buy-in, if you will, from judges that just won't buy in. But you know what, if judges don't, if there's the data, I mean, imagine could you just use it in real time, but perhaps for appellate issues, I mean, there's really no end to where the data could be used to the benefit of creating a more equitable criminal justice system.
And I think it'd be another 15 years before the Supreme Court makes the difference.
Yeah, could be.
I'm going to be more optimistic than 15. We'll stay in touch.
And to the point about data, honestly, you know, I know a lot of people who have tried to educate themselves about judicial elections. And, you know, because of judicial canons, there's a lot of things that judicial candidates can't say. And so if I was a voter, I would want that information to help me make my decision.
I've gotten the signal we have time for 2 more questions.
2 more questions. This one comes from online, Anna Williamson. What type of reform is going on in the juvenile courts with regard to dependency/permanent custody? Black people are disproportionately impacted by the current legislation. White heroin addicts are given support, but black cannabis users are having their children taken away from them.
I was thinking about something along those lines in thinking about the importance of judges not being biased, because you can't, you know, you hear comments that judges have made to white defendants that say, this shouldn't ruin his life, or talk about a loss of status in the community. And those are normally white defendants. And so it's almost saying that their status is a mitigating factor and not the loss of their status being a consequence of what they did. And I think that that comes into play in some of the cases that were listed in the question, because especially with the opiate epidemic, you know, when I was on the trial court bench, you saw a fair amount of cases coming from the suburbs, coming from suburban high schools in particular. And so I was very careful not to see those people differently or to appear as though I was valuing their life or their consequences more than I did the defendant that came from Linden or the defendant that came from Franklinton or 43207.
Hi, I'm Lance Crowfoot-Swade. Diane, sorry to put you on the hot seat, but I don't think you really mind being there.
I love it.
Yeah, exactly. So having sat where you sit some years ago, I really want to hear from you. What do you think law schools and law firms are doing right and doing wrong in terms of trying to diversify the bar? And even more importantly, do you think there's anything more they could really be doing, or do you think it's just that difficult?
No, I do, certainly. I think that law firms should be making pro bono work a priority. They should also, and I say that every law firm should have a pro bono director. You know, Ice Miller hired me in December. I'm the first pro bono director at Ice Miller. And that's progress, but doesn't denigrate the fact that there wasn't one before me. You need a pro bono director, and you need to engage in pro bono work for myriad reasons, but I would say that it ties also back to that law school piece. The firms have to work more collaboratively with the younger generation, with the law schools, not just for recruitment, right? I know that's the obvious answer, but to just build relationships and to build more of a sense of community. Let's all, I think we would all agree that the younger generation of attorneys actually cares about doing good, perhaps as much as they care about how much money they will make. And it is a missed opportunity if law firms don't appreciate the moral compass of the younger generation. We have to tap into that, and the pro bono work is a critical piece to that. I also, I have partners that say, talk to me about the ROI on the pro bono work. Here's the ROI, right, is that yes, it feels good, and it's personal development for our associates and of counsel, but it's also incredible professional development. We're also incredibly helping our communities, and we're being connected with our communities through nonprofits and the public defender's office and other entities that are game-changing in our communities. And I think going back to this empathy piece is the more that the law firms connect with players in our community that are really doing the work in the trenches, it will lead to more empathy on our part. I know Laurel said it, we have to stop living in our bubble. And one of the ways pro bono work forces us out of the bubble, and it also forces us to see that, not everyone is as fortunate to live like we do. And the law firms have to be part of that inclusivity, and we have to be working more collaboratively with them.
If I could address one issue so very quickly, because I've heard it from lawyers, I've heard it from judges, and that is Black people commit more crime. I take issue with that because if we went to a hospital right now and we looked at a Black baby in a crib and we looked at a white baby in a crib, and then we looked at them when they were 30 and where their life went, and one wound up in the criminal justice system, there's a million studies out there that show you the Black baby is more likely to have interaction with the criminal justice system. But when you're looking at those two babies in the nursery, they're just babies. When you look at them at 30, you have to consider everything that happened to them from sitting in that nursery to standing in front of a judge. And I would submit to you that there are issues of race, poverty, class that led them, that could very easily lead them different ways. I don't think that there's anything that supports that criminality is tied to race or genetics.
Well, it seems like our one takeaway from today is that we could keep talking. So maybe we'll have another a program like this. So thank you so much to all of you. We do hope you will join us again next week, Wednesday at noon online or here in person, where we explore the developing State House corruption scandal. So please don't miss that. Thanks to our live stream partners, WOSU Public Media, PNC, the Columbus Dispatch, and WBNS. To our online virtual seat patrons, thank you so much. And a special thanks to our speakers today, Diane Menashe, Judge Laurel Beatty Blunt, and I'll get it right, former U.S. Attorney for the Southern District of Ohio, Carter Stewart. We hope to see you again soon, and until then, please stay well, be safe. Thanks so much.